Welcome to week 10 of evidence. This week we cover the topic of opinion testimony. We'll cover the cases from your casebook from pages 783 to 820. The first case that we covered is Commonwealth v. Holden. This is a Supreme Court of Pennsylvania case from 1957, and the excerpt from your casebook is the dissenting opinion. As background, the defendant was convicted of first-degree murder. While under arrest, the defendant gave the police an alibi that he had been with Ralph Jones during the time of the murder. The police then questioned Jones in the presence of the defendant. And then Jones denied being with the defendant at the time when the murder happened. While this questioning was taking place, the defendant winked while facing Jones. At trial, Jones testified about the wink, saying he thought it was a signal to provide an alibi for the defendant. But after more testimony, also said maybe the defendant hadn't winked at all. At issue was, did the trial court err in finding that the defendant's wink had testimonial intent? Should a witness's opinion on the communicative intent of a wink be admissible at all? The majority of the court affirmed the trial court's decision without even considering whether or not Jones's testimony should have been admitted into evidence, essentially not dealing with the issue of how he could testify about a wink. There was a strong dissenting opinion which stated that the wink could have been unintentional or non-communicative, and also that no one could possibly know what it was intended to communicate, even if it had been given with that intent. The rule at issue here is FRE 701 and a similar California Evidence Code Rule 80. A non-expert witness may testify to an opinion if it is rationally based on the perception of the witness and is helpful to a clear understanding of the witness's testimony. And the dissenting judge here felt that this testimony about a wink could not meet these standards. Our next case is United States v. Stadmauer. This is a United States Court of Appeals case for the Third Circuit from 2010. As background, the defendant, here the uncle of Jared Kushner, appealed a conviction related to fraudulent tax returns for a limited liability company that was part of the Kushner real estate operation, which was called KC. A partner of an outside accounting firm used by KC testified against the defendant at trial. He testified that the defendant knew that some of the returns were false. The defendant objected that this was impermissible lay opinion testimony. The defendant also objected to expert testimony of an IRS agent, and the court discussed both of these objections. At issue was the testimony presented at trial proper? The appellate court noted that FRE 701 broadens the scope of opinion testimony, which was historically more strict. But it still excludes lay opinion evidence that only tells the jury which side to take. The court discussed that opinions about what the defendant did or didn't know, like in this case, come close to doing that. The court here analyzed the rule on lay opinions, which is that they must be 1, rationally based on the witness's perception, and 2, helpful to the jury. In this case, after analyzing these two pieces, the court affirmed the trial court decision. Our next case is James River Insurance Company versus Rapid Funding, LLC. This is a United States Court of Appeals case from the Third Circuit from 2011. As background, Rapid Funding owned a building that was burned down from arson. James River, the insurance carrier, refused to pay for the loss because the building had a negative value. They said it was run down before the fire had happened. James River tried to stop Rapid Funding's principal from testifying to the value of the building. The trial court held that the principal was qualified as an expert to give an opinion on the value of the building of real estate, and it was a building that his company owned. The trial court then held that the testimony didn't satisfy FRE 702 because the witness testified to depreciation costs based on a feeling he had. He was allowed to testify as a lay witness on this point, and Rapid Funding won a verdict at the trial court. At issue was whether the verdict for Rapid Funding was proper, and should the principal's testimony have been allowed. The appeals court reversed, holding that the principal's testimony should not have been allowed. The court held that the valuation testimony about the depreciating value was an expert opinion evidence based on technical or specialized knowledge, which is made inadmissible by FRE 701C. This rule creates an affirmative burden on the party trying to present that lay opinion evidence to show that the opinion does not require expertise. And the court here felt that that party had not reached this standard. Our next case is United States v. Moore. This is the United States Court of Appeals for the D.C. Circuit from 2011. As background, the defendant was accused of murder in support of a drug conspiracy. The prosecution presented an FBI agent as an overview witness. The FBI agent testified to an overview of what evidence the government would present at trial, as well as his opinion about the nature of the investigation in this case. The defendant objected, contending that the overview witness allowed the government to improperly introduce opinion testimony. At issue was should the FBI agent testimony have been allowed at trial. As a holding, the appellate court here concluded that the testimony should not have been allowed, but in this case, it was harmless error. The court identified three main problems with this type of overview testimony. The first was that a jury might treat the overview testimony as additional factual evidence that is strengthening the prosecution's case. Second was that the testimony might be a way to get in otherwise inadmissible testimony, which is a common problem with expert witness testimony. The third was the overview testimony would allow the prosecution to basically present a second opening statement. But again, here the court felt that even with these issues, this error was harmless. The last case from this week's reading was State v. Odom. This is a Supreme Court of New Jersey case from 1989. As background, the defendant was charged with possession of cocaine with intent to distribute. The defendant claimed there was no intent to distribute. The plaintiff's expert, a detective, was questioned on evidence presented at trial, asking him to assume that the defendant's house was searched and 18 vials of cocaine were found in a pillowcase, and that $24,000 was found in the apartment, and that no other drugs were found. The detective was asked his opinion on whether the defendant in this hypothetical could possess 18 vials of cocaine for personal use, or would that be for distribution? The detective testified he thought that, in his opinion, they would be for distribution. The defendant was ultimately convicted at trial, and the appellate court reversed. At issue was whether it was an error for the detective to testify to his opinion on the defendant's intent to distribute. This court reversed the appellate court and reinstated the conviction. The court held that a police expert could testify about whether narcotics were held with intent to sell. Specifically, the expert should not give an opinion on the defendant's guilt, but could characterize the defendant's conduct. While doing this, they should avoid using the language of the statute in question, and also that the defendant's name should not be used in the hypothetical questions to the witness. In this case, the defendant's name was used, but the court felt that that error was also harmless.